Okay, we're going to get started. So this is the vendor contracts, and I was telling somebody we've had Nick is good coming up with the newer, more cutting edge perhaps topics for us. So we appreciate him doing that again with vendor contracts. He's going to moderate this panel. He's a professional liability underwriter with Beasley, and I won't read his whole thing, but we worked with Nick prior to this. He's been an excellent speaker and moderator and chair for us. So with that, I'll turn it over to Nick. A hand for Nick. Somebody start clapping.
Thank you, Tom. Well, good afternoon, everybody. Is Vinny still in the room from the last session? He just left. Thank you. Well, unfortunately, I wanted to ask him to take a bow because he teed this subject up perfectly. Most of you, I think, were in the room for the last session, and one of the things he was talking about was the contracts with cloud providers. Well, we're going to take the subject a little broader, and the background here is, as an underwriter, I see a lot of crazy requests for coverage come across my desk based on what people are asking for in contracts. And talking to insurance brokers and talking to risk managers, I think a lot of people really struggle with how to put insurance requirements into contracts that make sense and doesn't put the vendor or whatever party needs to obtain the insurance in the awkward situation of not being able to procure the necessary coverage. On a personal note, I have to tell you that my girlfriend and fiance used to write contracts for the state of Colorado. We've had a lot of heated discussions around this because she doesn't understand why she can't get intellectual property coverage. I try not to have the conversation anymore with her because it usually ends up with me sleeping on the couch. So, with that as an introduction of what we're doing and why we're doing it, what I'd like to do is start by introducing our panel today. Right here to my right is Jim Gischek from McDonald Hopkins, who's an attorney. He's our official attorney on the panel, and promises to speak up vehemently if we suggest anything that's not legally correct. Next to Jim is Dave Lewison from Amwins, where he is in charge of their cybersecurity practice.
Management liability responsibility.
Management liability and cyber. I apologize. And finally, on the far right is Becky Pearson from Wells Fargo, who I understand has a lot of involvement with clients discussing contractual issues. What we thought we'd do to get things started today is give you a few examples of some of the things that we've seen in contracts that make our heads spin. And I apologize for these because when I put them up on the slides, they're probably going to be pretty much impossible to read. But I'll give you a few highlights and point out a few things that I think are relevant on each slide. So please don't try to read them verbatim. The first thing that we have are two examples that are actually pretty brief, and we kind of like their brevity. But I'll note in the first one, it uses the term cyber risk insurance. That might be a little nebulous. And then it asks for things like privacy breach response, business interruption, and cyber extortion. You might want to ask yourself why you would ask a vendor to carry those coverages since they're not going to benefit you in any sort of situation. We'll get into more details there. The second example below is kind of along the same lines. It's asking for things like fines and penalties and security breach notice coverage. And again, uses that cyber insurance kind of description. We're not sure, we'll get into that, if it's a good description or not for what you might want people to buy. Next one is a real interesting one. It's looking, what I'd ask you to note here is that it's looking for $10 million of coverage, which is a lot of coverage and may be significantly difficult for a lot of your customers to buy. So that may be an issue. The other thing that we noticed on this particular requirement was that it's asking for occurrence-based coverage. Yeah, I don't know if anybody's selling occurrence-based coverage in the room, but I'll let them talk about that at the cocktail party. This next one is going to span 2 slides. And why I picked this one is, first of all, because it's so darn long, it takes 2 slides. Which I'm going to suggest to you might be problematic, because if it's that long and complicated, it might be really difficult for someone to comply with. I think the most important thing here, though, is that, and they actually kind of summed it up nicely, and I've highlighted it in red. As a result from the provider's access to, use, handling, storage, transmission, or disposal of any data information. And this is where this one really gets me though. That I thought was pretty good. But then they say, and shall include, but not be limited to, and you'll see they list a whole lot of things. Matter of fact, I think they listed anything that they've ever seen in a cyber policy. You see that goes on to 8 points. And then it goes on even far, I'm sorry, to 10 points, 11 points. They broke the slide up on me so you could read it better, not knowing I was going to flip right through it. And then it goes into, in addition to the above, we'd like all this other stuff. So this is going to be problematic, I'm going to suggest to you, for an insurance broker to successfully meet these coverage requirements. This next one, what grabs me about this one is, maybe off, I think they broke this slide up too. This one is looking for $15 million of coverage. Again, a significant amount, particularly for smaller clients. And on the next one, you'll notice in here, if you read it closely, and I'm not going to ask you to do that, but I'll just suggest that what it's asking for in here are, again, breach notification coverage and credit monitoring coverage. I think in most cases, the coverage that a vendor or somebody can get is not going to be applicable to the company that's looking for indemnification or protection from the contract. So, then I think we have one more, and they've broken it up again, but this one is $25 million of coverage, and it's got an interesting clause in here. It says $25 million of coverage, if you can read that top line, and 1/3M in errors and omissions coverage. So I think that might be 1 million, 3 million, but I think, Jim, you're the attorney. Is that very clear? Probably not good for a contract?
Not good.
Those good softballs for you?
Yes.
Oh, it's nothing but softballs for sitting on this panel. The other thing that's in here that, again, I won't ask you to read, is this, in this particular clause, they're asking for the covered entity to be added as an additional insured. Now, that's something we frequently see in general liability and automobile liability coverage, but I think one of the points we'll want to discuss along the way is if and when that might be appropriate for security, privacy, cyber liability coverage. So, I think that's pretty much it for our examples. So, let's talk about some of the common issues that we've seen here. And Becky, I think you probably are first person with the client more than anybody else on the panel. So can you start by giving us some observations and some of the common issues and problems that you see with insurance requirements?
Absolutely. So to start with, a lot of the clients I work with are solidly in the small to middle market space. And a lot of them are actually handling a lot of sensitive information on behalf of their client. And the clients may be very large and are used to asking for large limits. So we'll have a client who maybe has only $50 million in revenue, but an insurance requirement will come in asking them to carry $25 million. And a lot of these large companies are able to negotiate those kind of limits out of their vendors, not realizing that some of these smaller companies just simply don't have the assets, the revenues to be able to support that kind of limit. And while we ultimately may be able to cobble something together, it's going to be far too expensive for that client to ever afford it, and therefore the value of the contract really doesn't make sense. So we have to push back a lot on the limits that are being requested. We've had primarily success, but I think that the numbers that are being thrown around about how much a data breach could cost a client are causing them to really up these limits in their contracts. I can tell you that I have a very solid middle market client right now that is going to be required by a contract to carry $100 million in limit, and they cannot negotiate it down, and we are going to put together that tower for them. But I'd say that's an exception, but we are seeing that happen, and it's simply because of the sheer volume of information they're going to have access to, that their client is terrified that they're going to be on the hook for if our client causes them a breach. Nick definitely touched on this when we start looking at the insurance requirements. A lot of the things that are being asked for are things that are solidly first-party coverages. They only benefit the named insured, and if you read the policy, they say incurred by the named insured or incurred by the named organization. I've had a lot of clients come back to me and say, well, we're really getting pushback that we have to have this benefit them. And the reality is that why would you want your breach response to benefit your customer? That's basically eating into your own coverage. And more to the point is, the client's really going to want to have full limits, which we're seeing sometimes you can get, sometimes you can't. Wouldn't it be better to have those types of costs fall under the liability anyway? So it's it's counterproductive to what the ultimate goal is, which is to make sure there's a backstop for those kind of expenses. You want to make sure that's falling under the liability, not the first party coverages. I had a client's customer get very creative and say, well, if it's set up that way, make us a named insured on the policy. And I just said, absolutely not. We are not making your customer a named insured on your policy, because then they can use it for whatever they want to. There's no way to really effectively limit that to this contract. It's not a good idea. So we see a lot of those kind of requests coming in. And I will also say the other thing I see missing a lot is when you have clients who are service providers, they're only asking for the network security and the privacy liability. They aren't asking for the E&O. And realistically, if your client is providing services to a third party, if they cause them a breach, chances are 9 times out of 10 is going to be caused by an error in their service, and that's going to hit the E&O first. So not asking for that is a serious limitation in the coverage, and we see that missing a fair amount. And then finally, just talking about insurance requirements that are unattainable. I see requests for patent infringement a lot. Even though that's not unattainable, it's not anything that somebody's going to enter into lightly. Nick touched on the incurrence basis, and then I see a lot of requirements for, we want to have this coverage and it has to cover intentional acts, affirmatively cover fraud. You know, these are things that just, somebody who drafted that contract doesn't understand how insurance works, and that there's no way we can do that. I think my favorite was today, I just had a request to review a contract come in that said they wanted the policy to include affirmative coverage for contractual liability and provide without limitation full coverage for the indemnification agreement in Section 13. So, you know, these are just things that, in theory, it sounds well and good, but when we're talking to clients about what we can reasonably get, and they're having to go back and tell their customer, this isn't commercially available, you know, that's a hard conversation to have.
And there was one of the examples that you flipped by, and you had stuff highlighted in red, and then in the middle, there was a part that stood out to me. It was on that multiple page one, and it said, I have it up here. It said, you know, including paper records, regardless of whether or not expected and intended. So I'm just thinking of situations where maybe you're intending to get this information out, and it ends up causing a problem. And so you pay somebody to do something, so it's intended, and it creates a big problem. I don't know, these contracts are a little crazy. And then you were saying something about it, I know we wanted to disagree, so I'm going to disagree on one. You said, why would you want your insurance to benefit somebody else other than yourself? And we've had a lot of insureds, mostly in like the record storage industry. Their whole job is protecting records. And they are very adamant about saying, I want the notification, credit monitoring, all that stuff to benefit my customer, because otherwise they have to sue me under my E&O to get it. And I'd rather not be sued by my customers, so let's have that pay. And there are some policies that will say that they're going downstream to do that. And sometimes you'll talk to an insurer who will say, well, we're not putting that in the policy, but we regularly will pay those on behalf of that other party to avoid that litigation.
And we have set up with clients before situations where the carrier is willing to recognize, hey, we'd be paying these kind of costs as indemnity anyway. You know, we're intending to cover those types of things. From my perspective, it's more of why would you want to actually endorse your policy to make those first-party coverages then benefit a third party when it's kind of understood that those costs should be covered generally under a liability claim, and maybe it's more of an issue of setting it up so the client doesn't have to sue you, but you know, you also don't want to dilute your ability that if you have your own breach, all of a sudden your client has already used up whatever you had. So it's more of a where do you want that expense to come out of, and what do you want to preserve for as a client for yourself.
And we've seen some parallels with architects and engineers on that, where we've had people want a client-specific additional excess, where somebody will say, I'm only buying a 1 million or a 3 million, and somebody wants 10 million, and they're saying it's too expensive to buy that for all my customers, so let's narrow it down to that revenue base. And sometimes the underwriters will push back, especially if it's like a record storage firm where you have stuff all stored together in the same place, so one breach impacts all, and you're not, now you're paying to sort out, who am I helping, just these people or everybody else? Other people are benefiting from all my work. It gets to be a big mess, so it's all these guys' fault, the attorneys.
That's what we always hear. But no, when we get involved, I mean, one of the first things before we start to talk about coverages, we sit down with clients and we're asking them, well, let's see what your contract looks like. Or if they want us to draft a contract, typically we find that people try to make things that are far too complicated, far too convoluted. We'll get contracts, there's defined terms that are not defined. They're horrible. So then we find ourselves trying to figure out what happened during this process as they were drafting and negotiating this provision. Back in 2010, I was thinking back, when Massachusetts came out with its statute, we went through all of our client base and drafted a one-paragraph addendum to add to every vendor contract. One paragraph, that was it. Very simple, very straightforward, covered them. And folks thought, well, there's got to be more. Why shouldn't it be 3 or 4 or 5 pages? Well, because you didn't need 3 or 4 or 5 pages. And unfortunately, what we're seeing now is that many of these contracts are so complex, they don't even know what they've entered into. And they wanted something very straightforward and simple. They know what they want. They just haven't had an attorney that's drafted something that will get them what they want. And that's probably the biggest problem that we see.
Well, let's break this down just a little bit. Do you guys, unrealistic policy limits, I think what we're saying is there needs to be some consideration for the size of the client and what's commercially reasonable for them to buy. But do you have any thoughts on how to set an appropriate limit, what a good limit is to put into a contract?
Well, I think that's a big challenge because you look at how the underwriters even evaluate privacy. Some people go off revenue, some go off record count. So I'll go back to the record storage firm example. We had one in the southeast that they get a contract from the health system and they're just moving a box and storing it somewhere. But in that box there can be a USB drive, a hard drive, or whatever with all kinds of data. And they signed a contract, like a business associate agreement that said, we'll be responsible for anything that we lose. But they usually put in subject to the value of whatever we were paid, but that wasn't on there because they just agreed, oh, this is a big customer for us. And I was on a panel like this, and my client was in the audience, and then he just turned white and he said, man, we know that they have 1 million patient records plus, and if we lost it, we got paid 30 grand for that contract, but the cost to everything that we agreed to do, notification, credit monitoring, all this stuff could be in the tens of millions. I'm out of business. So how long is that contract? He's like, well, it's at least another 2 years. It's like, I'm not going to sleep for another 2 years. But terrifying. So how do you evaluate that? Because there's one where the revenue count would be really low, revenue size, but the record count could be astronomical. So as a broker, how do you come up with a number? It's tough.
Yeah, and I mean, I honestly don't have a good answer for that beyond what typically what we're seeing is, well, I know the revenue size of this client, I know what carriers are willing to support in terms of a limit, and that's usually what I try to suggest of, based on their size, this is probably the highest limit we can get and still have it be a commercially reasonable price, see if you can get there. Sometimes we do, sometimes we don't. Like I said, I have a client where we're going to build a $100 million tower simply because they cannot get out of that requirement, and the contract is actually of enough value to them and for a long enough period of time that it makes sense for them to do that. But we did a lot of modeling on what that was going to potentially cost them so they could build that into the contract, some of it at least into the contract value. But I think it's really a question without an answer, because to give the comfort level to the client's customer, they may or may not be able to do that. The client has in their mind how much this is going to cost them. And I can tell you with that contract, we did do some breach calculations for them and showed that it would, probably 50 million would be the maximum if every single record was breached. And that still didn't get us anywhere. So, if you there are insureds out there who have the revenue level to get those kind of limits, and they end up winning a lot of those contracts simply because at some point there's not a lot we can do for our smaller revenue clients based on the way that the insurance is set up.
And you have to ask them, what are you really touching anyway that you could actually have this responsibility? Right. Because if there's a standard contract that they're using for everybody and this particular vendor is just watering plants, you have to be able to push back on that. and hopefully people are reasonable. And then is that the person who's forcing that down, I don't know, Nick, is it fair to ask the moderator a question on this?
Absolutely.
If you're writing that bigger entity that's forcing it down, do you ever ask, are you able to shift all your cyber liabilities off to your vendor so this insurance can be cheaper for you?
I've had many a broker come to me and suggest a price discount on that very practice.
And what's your response?
I'd probably say,
How about those flyers?
yeah, how about those flyers? Yeah, I'm sorry, the state won't let me credit you for that. Oh wait, this is surplus lines. No, we just negotiate it as anything else. But certainly one of the things we look at in all seriousness, as an underwriter, how well they manage contracts and responsibilities, and if they're able to get vendors to step up in the right way, that will be a positive aspect in the underwriting of the account and will result in a lower price. It's the same thing with Techno, right?
And I thought that was a good point you made about the E&O. We've been big fans of the brokers that when selling the blended policy with E&O and cyber, because you can't tell which side something's going to fall on. And if you can take care of both and the price is the same or better, why wouldn't you? And then there's that dilution issue you're talking about. But still, you want the coverage to respond, not argue over who's doing what.
Let's take the next step and let's move on. Let's talk about. We have a couple more common issues. Just to make sure we touched on these. Insurance requirements provided under coverage specifications. Oh, cyber liability or privacy liability. We see this a lot. And I'm not sure if anybody mentioned it or not, but those aren't real defined terms. So if you're going to rely on those terms, you may not get the coverage that you look for. And then again, we see a lot of times contracts just not saying no, silence. So with that, let's talk about why we have insurance requirements, so we can use that as a building block for maybe what things we could suggest to people to build better insurance requirements. Dave, do you have any thoughts here?
Well, I think that's the whole reason for pushing the insurance is you're dealing with a vendor that's smaller than you. Think of that Target breach with that HVAC contractor. If Target wanted to say, we are now incurring $1 billion of expenses because of your security weakness, there's no way that little vendor could ever pay. Even if you told them to buy a $100 million tower, it would never be enough. So I get why people need the insurance and why we're talking about it, that what you're asking for may not make sense and it may not be the solution you're looking for. But you do need some sort of backstop to supplement that vendor's balance sheet and the promises that they're making. And we have clients that'll just sign those things, feeling like, well, I want that revenue. The contract, we just won't screw up.
So we are looking for an element of financial security.
The other conversation that I have with clients a lot, especially when we're having conversations in renewal about the limit they should carry, I absolutely recommend that they go back and do a contract review and see how many times they've promised their limit to various customers, especially when we are talking about clients who may be aggregating data or in some way manipulating their clients' data. If they have a massive data breach, all of a sudden they've promised, their 10 million limit to 50 different customers, and they've all been breached, and now all of a sudden, even though there is some financial stability there in theory, there's no way that policy is going to be able to satisfy all the claims that potentially could come in. So it's also, coming up with that, what's the magic amount to ask for? That's difficult, and it's also difficult from the client side to say how much is appropriate for me to carry, considering how many clients I have and how many times I've promised that limit.
Yeah, I think it's a lot like automobile insurance. We're all required to carry automobile insurance to drive, and we're required to carry minimum limits. And that's just to make sure that there's some type of financial backstop, some financial security that if we do get into an accident, that there's some assets there to compensate the other party. It's not intended to be perfect. It's not intended to cover everything that possibly could go wrong, but it is intended to provide, I think as Dave said, a backstop. The other thing to keep in mind here is that it provides some due diligence because the underwriter is putting their assets behind the company. It's probably not perfect due diligence. Nobody's necessarily going in and looking under the hood, but there is an underwriting process, and that should give some demonstration that the contractor or the other contracting party is capable or has minimum qualifications to do what they claim they're going to do. Dave, did you have a comment?
I already forgot what my comment was on the last
Okay.
one. So on this one, I agree. I've had people say, we want to figure out what our security looks like or how we measure up. And somebody just said, well, just fill out that application. That'll get you a good starting point. But the application could be 3 years old. There are all kinds of different things going on. So it's not the perfect self-assessment, but it's definitely better than nothing.
All right, let's talk about the downsides of insurance requirements. Dave, Becky, any comments here?
Well, as I said on the contract that I was looking at today, where it said that it wanted contractual liability to cover without limitation the indemnification provision, I think the conversation I have the most often with clients is your customer contract and your insurance contract are entirely separate contracts entered into by different parties and with different obligations. So if you're expecting that by carrying this insurance, if your customer is expecting that by carrying this insurance, they can just come to you and say, I'm collecting on my indemnification provision, that your insurance is going to respond to that, I think that, probably kidding yourself a little bit. And so that's the education process we have to go through, which is, I'll also get the question of how does this contract impact my insurance? Well, it doesn't impact it at all because they're completely separate. But, you want to try to line things up as much as you can, but the reality is that insurance is triggered by certain events, your contract is triggered by certain events, and they may not necessarily cross over.
Well, it's rare that we'll see a policy that doesn't have a breach of contract exclusion either. And there are those carve-backs in there for liability exists in the absence of the contract, or privacy policies will mention any privacy policy more internal, but you're always going to have to battle that. And some of the policies will say, go even a step further, liability established in a contract or assumed liability, things like that. So there's always going to be that hurdle, what's in the policy.
Yeah, I think you guys nailed it, that the important thing here is that this is not a service guarantee. The insurance company is not guaranteeing the service. They're not providing any guarantees. But as we said on the last point, it's meant to be a financial backstop. All right, now we're going to put Jim on the spot because Jim has been kind enough to give us a straw pony of some alternative language that we might want to look at. And I should say that this clearly is not intended to be legal advice to anybody, so please don't take it that way. It is clearly not going to be perfect or appropriate for every client that you're going to run into. But I think what we've tried to do here is give you an example of something that's a little simpler and a little more straightforward. And so let me walk through it with you real quick. The vendor shall maintain liability insurance for the duration of the contract and or the period of time in which the vendor or subcontractor maintains, possesses, stores, or has access to company data with, I can't quite read that, I need glasses, whichever is longer with limits of not less than for each claim, and in the aggregate of a certain amount covering the vendor's liability for a loss, theft, unauthorized disclosure, access or use of company data, which may include, but is not limited to, personally identifiable information, payment card data, and protected health information. So let me ask you some questions, Jim. Right off the bat, you didn't use the term cyber liability or privacy liability. You just said liability insurance.
That's because you wanted this all to fit on a cocktail napkin. So that was, my first requirement was it had to fit on the cocktail napkin at the bar. A couple points. The first thing I want to mention is talking about going beyond the contract period. We've had a number of cases where we've had vendors, contract ends and it's 4, 5, 6 years later that we're notified that they've been hacked into. They've lost some device that has our information on it. And we've seen some contracts where they specifically state during the period of our contract. Well, you have a problem because now we're going back, we're trying to prove, well, one, did it occur during the period of the contract? No, it didn't, it occurred afterwards. So they've got an issue. So we want to make sure that whatever we're agreeing to contractually, that it's giving us that protection for as long as they have our information. So we want to make sure that that's the case. Relative to putting certain terminology out there, as I mentioned before, we're very careful to make things broad enough to capture everything, hopefully, that we're talking about without putting in real specific labels, if you will. Unless you want to have very specific defined terms. typically we see contracts that have what appear to be defined terms, but they're not defined. So now it's open for interpretation. And for all of you that have the pleasure of going through litigation, there's nothing like spending hundreds of thousands of dollars on your lawyers to argue about what this particular phrase means. It gets very frustrating. And clients hate it because they can't figure out why we just can't file a motion for summary and get this over with. Well, it's because whoever drafted it did a horrible job. So we want to make sure that we're covering everything, but we're not being so specific with language and undefined terms that we find ourselves being boxed out and have a situation where now we've got an issue that's not covered by that particular defined term.
Okay? And you've described the insurance pretty succinctly, using some pretty common things that are found in language: loss, theft, unauthorized disclosure, access or use of company data. Again, can you talk about that and why you didn't feel the need to have a long laundry list here?
Well, as we've gone through this and looking back at cases that we've handled and other cases, and obviously talking to all of you, we've tried to come up with language that we thought would cover all of the particular items that would come up without giving the laundry list of very specific items. And the one word that we added and that we've added a while ago was access. We're seeing a lot of cases where we know something's been accessed. Now the great debate is, well, has it been taken? Has it been misused? Has it been disclosed? So if all we've got is access, the first thing they look to is, well, gee, we don't have to worry about we didn't breach the contract. All they did was access it, but there's no evidence that anything was taken or misused. That is by far becoming one of the biggest issues that we fight over every day when we're dealing with incidents and breaches. And so we're very careful to make sure that we cover that.
All right. Last but not least, you went to, well, you used the term company data rather than trying to describe every possible type of information that they may hold. Any comments there?
Yeah, again, this goes to making sure that this is throwing a broad net. I think if you try to give the laundry list of items, you will inevitably miss something. It's guaranteed you're going to miss something. Because even if you sit here, the day that you draft that contract, the next day, there's going to be some other type of data that you didn't include in that list. So if you try to create the laundry list, you're going to be going back and amending that contract every other week to make sure you're capturing it. You don't want to put yourself in that position. Because what happens with these contracts? People draft these contracts, companies draft them, it goes to legal or whoever's going to hold them, they get put in a file drawer and nobody sees them again until they have to break the glass because there's a problem. So nobody's going back and checking these and saying, boy, did we include all the right language? Do we have all the right coverage? That never happens. And again, when we go in and audit companies, one of the things we're asking them is, well, let's see a copy of all of your contracts. When was the last time you looked at these and updated them? And you get blank stares. You know, it was drafted and there will be a date on the bottom. And they haven't looked at it since. So we want to be careful that we are all encompassing. We don't have to go back necessarily and amend when there's new information.
Makes the contracting process easier, I
Yes.
imagine. Becky, Dave, any comments on the alternative language?
I think there's definitely wisdom in the brevity. And at first I looked at it like, oh, it's missing so many things, but I like that it's that broad. You can fit a lot in there, and it doesn't attempt to define things that would fit in a policy. I've seen contracts where you can tell somebody's looking at an AIG policy and they're making it so it would fit, and you're binding with somebody else where the language is totally different.
No, I agree. I get the question sometimes, well, what kind of insurance would you recommend that our vendors carry? And I always say, realistically, all you need is the E&O and the network security and privacy, or the E&O that doesn't have a network security and privacy exclusion on it. And that's probably going to cover 99% of the situations we're talking about. So I think keeping it simple, not only does it make it easier on the client, but it also makes it really clear about what we're talking about.
Okay. Well, let's a couple of thoughts on drafting and assisting clients with insurance requirements and contracts. Dave, do you want to talk us through this?
Yeah. I guess the starting point of every contract should be what are you trying to accomplish with this? Is it a shifting of liability, or is it making sure there's a policy there in the event something goes wrong and you sue, that financial backstop aspect? And if somebody has been just recycling an old contract and not updating it, like you were saying, what they're putting out there may not be doing at all what they think it's supposed to do. So that's, where I would start if somebody says, what should be in there? Well, what are you really trying to accomplish? Do you want to share your limit with your trading partners? Do you want it to extend that way? Or, like I said, is it just going to be there when somebody wants to sue you? Then also, if you want to get specific on how you're sharing, that's a whole nother thing. We've had healthcare providers saying, we want them to pay for it, but we want to control who does notification, what it looks like, who they use, and whatever. And that's just a big mess, especially if you're dealing with an insurance policy for a vendor that has its preset who they're going to use. So you always have to figure out what's your goal of the insurance, and then let's figure out if the mechanics of your contract are going to match up with the insurance. And usually once we're involved, the contract's at that final stage, and there's not a ton we can do. I don't know how you do on pushing back a little bit.
Well, I think you're very optimistic about the fact that it's at the final stage. I sometimes get it after it's already been signed and in effect for 6 months, which is really great to then have to go back to the carrier and be like, yeah, they sort of already agreed to this, so is there anything we can do? But I think, the conversation I have a lot, especially when we're talking with clients who are entering into vendor contracts, just making them very aware of what some of the limitations are of what a vendor can actually do for you. And I also very much like to point out, you aren't their only customer, so you need to protect yourself first, because if something goes bad, you probably are not going to be the only customer impacted. And at that point, the vendor is most likely to be in the position where they're trying to shield themselves from litigation, so their priority is not going to be you. So you want to make sure that you're in the best possible, in theory, we would like all of our vendors to work with us, but you want to be in that position at the end of the day where you're covered. You've set it up so you have recourse against the vendor, but you're not dependent on them to make sure that things run the way you want it to run. And so that's typically why we don't recommend that our clients rely on their vendors for any sort of breach response, and why I also don't recommend they delete those limits for themselves.
Yeah, on the breach response, we've seen this go horribly wrong when folks put this in contracts, because they completely lose the ability to control the messaging. And what happens is then they do that, somebody's providing the notification, and we get the phone call that says, have you seen what they drafted and what they went to the media with? Yeah, well, congratulations, you signed the contract. Great job. So we're always encouraging them, look, if that's something you're going to be worried about, which you should be, you want to make sure that you're controlling that process.
So what about the idea of including a requirement for the vendor's forensic investigator to talk to yours and work together?
I think that could be, I haven't seen that in a contract, but I think it would be pretty interesting, because you don't want to just have the insurance there for when you sue for a problem. I think one of the huge benefits of buying the cyber insurance that I think people have gotten better at selling is that whole service component. That it's nice to know that if your vendor screws up and loses your data, you can sue them and then somebody's going to pay. But knowing that you're going to get that, or at least they're going to get that whole suite of forensics and great legal advice, and it's protected by privilege and all that, that's helping sort of box in and reduce your risk. Even though maybe you're not passing that all along, they've got professionals that are helping them do it right.
I definitely agree with, in some way, addressing the forensic investigation, whether it's by contract or a side agreement. I actually had a client that had a breach yesterday, or we were notified of the breach yesterday, and actually it turns out it's not the client's breach, it's their cloud provider's breach. And so a lot of questions are coming out, we're trying to get information, we're trying to assess what's going on, the carrier's trying to assess what's going on, and of course what they're telling us is, well, the vendor it's their breach, so they've engaged the forensic investigator and they aren't sharing this information with us, so we aren't exactly sure what's going on. And while they have been getting some details about, we think it's this information, we think that it's this number of records, we think it's social security numbers, it's 490 people in 7 different states. There's no indication of how it happened. There's no confirmation that this was actually accessed or disclosed. It's just very gray because it's not their forensic investigator and the vendor is under no obligation to share that information with them.
And from our perspective, we always get nervous to the extent that they've agreed to this, because from a litigation perspective, anything that one of our agents or reps are saying, it's going to be deemed an admission against interest. So the minute that they go out and start saying, let me tell you all the problems we have with our organization and why this happened, great. That's going to be spectacular in the lawsuit. So we're always very concerned. We don't want our folks sharing information directly with them.
Right, and it's certainly a conflict that is hard to resolve, because on the one hand, you know, our client needs the information to be able to figure out what they need to do. Your client is needing to make sure that they protect themselves from litigation, and so it really puts everybody kind of in a bind in figuring out what's going on. You know, I can see that there's no perfect solution to this problem, and you know, we have talked before about, you know, allowing either access to logs or allowing an independent investigation. Whether or not a customer would ever, a cloud vendor would ever agree to that is a whole nother question. But, you know, you just have to be aware going into this situation that if you're handing over your information to somebody else, that a situation like this may arise, and it can create a lot of gray area about what even your obligations are.
The other issue that I'll point out is we've had a number of clients recently that have said, well, don't worry, before we engaged you, we've been talking to the other side, and what they've suggested is a joint defense agreement. I said, well, that's great if somebody's suing all of us and we're on the same side, but the problem is we may be suing each other. So we really have to take a step back and look at the bigger picture, what may happen down the road before we start agreeing to things contractually.
I think that's what's neat about your alternative language too, that or it's subcontractors, because we know with high tech and business associate agreements, things are going downstream to not just you, it's to whoever you outsource to. But it doesn't say make sure your subcontractor has the same requirements that they're requiring of you. Something like that would be really interesting. You may never get it, but and then I know the last panel was talking about cloud. I think one of these contracts said something about if you're holding our data, you have to hold it in the U.S. There's a whole repatriation of data from foreign venue problem. That if somebody does sub it to a cloud vendor, and then maybe that's a smaller one that goes to another one, who knows where your data is? Just a nightmare.
So that's another good point. Are there other aspects of the breach response that we should think about working into the contract to make sure that there's cooperation?
Well, again, I mean, from my perspective, Nick, I mean, when I talk to clients, my whole perspective is you want to control the process. I mean, to me, that's key. If you can't control the process, you have no idea what some other party is doing. And I can assure you that unless you are their number one customer or client, they are going to be looking out solely for their best interests. And even if you are, they're still going to be looking out for their interests. So controlling that process to me is critical.
I would agree. I typically, like I said, only tell my clients to ask for the liability insurance, and everybody let their breach response be for themselves.
And you never ask a question without having an answer in mind. What were you thinking on that?
You know, that's why I'm not an attorney. I'm just curious what you guys would think. All right, we have a couple of other suggestions here. Do you guys want to comment on these items?
I think some of those were already covered. We talked about limits. That's always the biggest shock, is when there's somebody's demanding an unrealistic limit.
Yeah. I like avoid reaching for ideal coverage, because I think that's what a lot of times what attorneys do when they're drafting contracts for their clients. They describe what they think would be the most perfect thing in the world, but as we've talked about, that just doesn't exist.
Damn lawyers. Yeah, of course not. I do want to go back to the linking coverage to the issues of concern. I think if any attorney is doing their job, the first thing they're going to want to sit down with their client and say, well, what is it you're concerned about? Let's start there, because as Nick mentioned, we can draft the 20-page agreement that no one's ever going to sign, and it may not cover what you're concerned about. So I mean, we always start basic with clients. Before you make this too complex, what are you worried about? And sometimes it's us telling them these are things you should be worried about, and having that discussion up front, and then starting to draft, again, a very straightforward and short, abbreviated contract, one that folks can look at and live with.
And I think goes to part of the problem of you get a client who works with their attorney to draft contracts, and then because they don't want to pay to draft an individual contract every time, turns it into their cookie cutter, and I'll add A and a little bit of B, and we'll put C in, and we'll use this. And I think that's where we end up seeing a lot of these kind of crazy limit requests and coverage requests. I had a client who actually is a media client who was being asked to carry tech E&O with contingent bodily injury and property damage, and my first response was, do you even provide technology services? Why are they asking you for this? And of course it turns out it's some standard contract that nobody bothered to read before they handed it to our client to say, sign this. So I think that's where part of the problem comes in, is once everybody gets comfortable with the contract they like, they just start using it for everyone, and it may not actually fit what the particular service is, or what the subject matter of the contract even really is.
Yeah, the other issue that we've seen much more frequently is we'll be negotiating this contract with somebody who does not understand this area.
Right.
So we're dealing with the environmental attorney or the tax attorney. Well, that's fabulous. If I want tax advice, I'll come to you. But if I want to negotiate this contract, maybe you're not the best person to do it. So it does get a little frustrating because we're talking a different language than they are, and they just don't understand it.
And I think that can also be said of the insurance requirements, that most of the time a client doesn't understand what insurance actually does. So when their attorney says you should ask for this insurance, they assume that applies for every single situation. And the thing that I see creeping in, especially on the E&O and the network security privacy requirements, there's a lot of, because you can get it on the GL, it gets asked for a lot on your line of insurance, like waiver of subrogation, primary non-contributory, additional insurance status. And a lot of these things, for many reasons, don't work the way they should on the E&O, and it really puts the client in a bad position to be having those things built into the contract. But you'll find that there are a blanket requirement for all lines of insurance, and it really has to do with people not understanding what the point of the insurance is. Being an additional insured on that E&O policy is that, I think we had a bullet point up there, is that really going to accomplish what you want? Because then all of a sudden one can't, unless it's set up right, one can't sue the other because they're both insured under the policy.
Yeah, one last thing that, Dave mentioned something about the final rule and things being pushed down to business associates and sub-BAAs. One thing that we're seeing a lot of is in business associate agreements, folks are starting to pack in a lot of these types of provisions. And there's a lot of indemnification and other provisions that they're going through and completely rewriting these agreements. And they're very long and they're very convoluted. And we're finding a lot of clients, they're seeing them and they're just signing randomly these business associate agreements. They're not really reading and understanding what it is that they're signing. And then when they do have a problem, we go back and say, great, let's take a look at your contracts. They're clueless as to what their obligations are. And they have very significant obligations, and it becomes a real issue. So, just right now, folks are going back and they're sending out new and revised business associate agreements or sub-BAA agreements. You want to make sure that folks are actually reading these and understanding what they're agreeing to.
All right, well, we only have a couple minutes left, and there's a break after this, so I know nobody wants us to run long. Are there any questions out there before we sum up? Okay. Well, if there are any questions, feel free to catch us in the hall or afterwards, but just to sort of sum things up then, I think that everybody's in a difficult position in this room, because unfortunately I recognize you're not the audience that has the power to fix a lot of the problems we talked about. But I do think that you're the people that work with the clients that are trying to resolve their business issues, trying to get their contracts taken care of so they can go do what they do and just get the contract agreed to and out of the way. And a lot of times, particularly the insurance broker is seen as the impediment to getting the contract signed because you can't meet the crazy insurance requirements. So what we've tried to do today is really give you some ways and some ideas for how to talk to your client about these issues and how to work with them. If I could just sum up a couple of the things that I think I took away, is you want to start by keeping in mind what it is that you're worried about, what's important about the contract. You want to focus on the key issues, but the key issues for this contract, I think, Jim, excuse me if I get wrong who said this, but standard things that you ask for in every contract may not be appropriate in this situation, so why let them get in the way of getting things done? The next point I think you want to keep in mind is it's really a great opportunity for you to talk to your clients about how cyber insurance works, if I can use that term. Security and privacy insurance, a lot of insurance people struggle with how it works. So we know the clients are struggling with it, so they don't understand that breach notification cost coverage maintained by the vendor isn't going to provide them any benefit. What they want is indemnity coverage for their breach notification cost so they can recoup their loss. But that breach notification cost coverage isn't going to be the right coverage. So I think there's an opportunity to talk with the client about that.
And I was just going to say, I think the theme, if I had to sum it up, is keep it simple.
Yes.
Thank you.